Supreme Court of Florida is now in session. Please be seated.
We now turn to the final case on today's docket, Love versus the State of Florida.
Good morning. Mr. Chief Justice, and may it please the Court. This Court has always held that burden of proof provisions are procedural in nature. The burden merely provides a means or method to adjudicating, enforcing, and litigating underlying substantive rights. As a result, the burden of proof provision in this case is both procedural and therefore presumptively retroactive to all pending cases. That is essentially what this Court recognized in Bretherick, where considering the question of which party should bear the burden of proof at a stand-your-ground immunity hearing, the Court repeatedly characterized that question as being one involving procedure. On top of that is the fact that these legislators clearly believed that what they were doing was adopting corrective legislation, the purpose of which was to effectively put criminal defendants in the position that they would have been in but for this Court's decision in Bretherick. And the only way to give full effect to that legislative policy determination would be to apply this new law to cases like Miss Love's. I'd like to start today.
Well, let me ask you this. If you just look at all this on its face, the legislature passes a statute that changes the burden of proof in particular proceedings. And there's an effective date for that change. And the most common sense way to understand that is that the hearings, the proceedings that take place after that effective date would be proceedings in which that new burden of proof would apply. Now I understand that's not what you're arguing, but that still gets your client what your client needs on that question. Why wouldn't that be the most common sense way to understand such a statute?
And in fact, Chief Justice Kennedy, the statute itself says in a criminal prosecution at a stand-your-ground immunity hearing. So when the judge would look to determine what's the burden at that hearing, it would look at the burden in effect on the day of the hearing. I think that makes a lot of sense. Our position is somewhat broader. We say all pending cases, but you certainly could resolve this case in Ms. Love's favor by saying that it applies to hearings held after the date that the law took effect.
Well, let me piggyback on that, because and this is confusion. I want you to educate me on this. What's the purpose for retroactivity purposes of this procedural substantive doctrine? You do a great job in your brief of talking about the different presumptions that arise, and it all seems to be, we don't really know what the legislator's saying, so we've developed all these tests and presumptions that are there. What's the purpose of all of this?
I think we know what the purpose is, Justice Luck. It's to protect reliance interests. So the way that you have defined the difference between substance and procedure, substance is, under Garcia, when you declare what acts are crimes, that's substantive, and people are going to rely on that.
Well, I understand the tests.
I am trying to get at.
Well, let me ask you this. Let me ask you more specifically. Is there a constitutional difference between substance and procedure for retroactivity purposes, or was this just a test developed just so we were able to give some guidance about finding when something is procedural, when something is substantive, or when it applies retroactively and when it does not?
You have said in other cases that the due process clause does contain, and because of reliance interests, the distinction between substance and procedure.
But that wouldn't affect this particular case because it's retroactivity inures to the benefit of the defendant, correct?
Correct, at least under the ex post facto clause, that's correct.
Well, even under due process. I mean, in other words, he's getting more rights, not less rights as a result of this. So there's no constitutional implication. I guess what I'm asking is, it seems like we're working backwards. It seems like we're trying to guess at substance procedure through these very difficult and inaccurate tests that we've seen to describe a lot of different ways over the years, to try to get at presumptions, rather than just doing what Justice Kennedy just asked, which is, let's look at the statute. If they say retroactive, if they say start now, if they say start later, we do what they tell us to do. And then ask the constitutional question.
So I think to the original question you posed, the reason that I was mentioning reliance interests is because that really does inform what you call substance and what you call procedure. The reason I say that is, in the context of the criminal law, when you define what a crime is, people will rely on that, because if you say it's A, B, and C, that's what the legislature says, people know if I do those things, I'll be held accountable, but if I do something else, that will be perfectly fine, the law will allow it.
But-
It would be unfair to change that.
Well, but those kind of lines of analysis regarding reliance interest or vested rights, that's all kind of swirling around this. I struggle with understanding how that makes any sense in this particular context, where we're talking about the rights of the state. Now, the state has no vested rights that can't be taken away by the state, by the legislature. Now, we've got this constitutional provision, which is a separate matter, Article 10, Section 9. We'll look at that separately. But in terms of vested rights or retroactivity, I'm just struggling to understand how that makes sense in a context like this, where the legislature can decide, well, the state, we're going to forego this that we could have had, or whatever. I just don't. It just seems like to me to bring in conceptual confusion, and particularly in a case like this. What do you say to that?
I think that's a fair way to approach it, but within the existing doctrine that you have these sets of default rules against which the legislature understands that it acts. So when it adopts a matter of substance, that's going to be future-looking. If it's merely procedural, and all of your decisions and all of the district courts that have looked at it, this court presumes that that will be procedural. So even setting apart the fact that the government can abrogate its own rights at will and that can apply retroactively, one way or the other under existing doctrine, if this is procedural as we believe that it is, then it is going to presumptively apply to many cases.
Doesn't it seem we're getting it backwards? We seem to be asking the constitutional question. So let's say, whether you call it reliance interests or vested rights, as the Chief Justice has called it, those are constitutional questions. And then we're answering, well, what's the statute say? It seems like we're flipping that. To me, shouldn't we ask, what does the statute say? And only if the statute implicates something looking back or changing someone's reliance or vested interest, then we ask the constitutional question. And I think, as I noted here, it seems odd to ask a constitutional question when it only inures to the benefit of the defendant, which I think is what the Chief Justice is saying too.
That makes sense to me. We have been operating within sort of the confines of your existing doctrine on legislative intent.
I don't blame the brief. I'm merely asking these questions because maybe we're looking at it wrong. Maybe we've been analyzing these things in a way that doesn't really make sense and has us decide very thorny constitutional issues before asking the question of, what does the statute actually say?
What's the original public meaning of Article 10, Section 9?
I think that to derive the original public meaning, you could look at the way that Article 3, Section 32 was interpreted by courts. That was the predecessor to Article 10, Section 9, and it had always been understood by this court to encapsulate a distinction between substance and procedure. So when Article 10, Section 9 comes along, the public, understanding that that has always been how the predecessor was interpreted, that the new savings clause would also have the distinction between substance and procedure. The purpose of the savings clause is to prevent the legislature from destroying crimes that previously existed.
So what's the textual basis for that distinction, though, in terms of the actual language here?
Well, the way that it's been understood is that the shall not affect prosecution means if you were to destroy a crime that had been committed, if you were to take that off the books, you can't do that retroactively. That would affect prosecution. But in many cases, you have said that anything less than that, dealing with modes of procedure, like the Glendenning case, what evidence can come in within the confines of a prosecution, that's merely procedural. So I don't know if that gets to your question, but what I can tell you is that the case law looking at the savings clause, which for reasons we listed in the reply brief, we think is no longer applicable to this case at all, but your cases have always drawn the distinction that we've pointed you to here. If I could say a few words about how we think burdens of proof actually operate and why we believe that they are procedural, like the Second District said in AW, what a burden does is not change the elements of any crime or the affirmative defenses of a crime. It's not like Smiley, where conduct that previously was unlawful the day after the amendment becomes lawful. What the burden does is just provide a measuring device for use by a fact finder within the confines of a judicial hearing, and that looks in all respects like what you have said is the classic definition of procedure, a law that allows means and methods, the mode, machinery of the judicial process.
If we're literally reading our precedent, though, in other words, if we're going that route, how is the state wrong to say, and how is the third DCA wrong to say, that Smiley said new legal burdens are part of what is substantive, and here it's a new legal burden, since the burden is now on the state when it wasn't before? It seems pretty logical reading of that. How do you blame the third for reading it that way, and the state for that matter?
We think that what the third district did looking at Smiley was to take those words, new legal burdens, out of context. Every time this court has used that phrase, it was truly talking about something substantive. In Spiewak, creating a new element of a cause of action, Arrow Air creating a brand new cause of action, Smiley changing the elements of affirmative defenses. So that's when the term has been used, it really did refer to actual rights and obligations of real Florida citizens as they operate in the world. Sort of when the legislature tells real people how to interact and how to behave in their actual real world existences, that's substance. But this court has never suggested that a burden of proof would be anything but procedural, and in fact, in multiple cases, you've said exactly that, it's procedural. I would point you to your decision in Walker and LaBerge versus Halligan, which I think is a useful case for us because it draws the distinction between, on the one hand, the substantive right to immunity, and on the other hand, the burden of proof that simply governs how you determine is a person immune or not. I would say one last thing and then I'll sit down, which is that I think you can tell in a big way that this is not substantive because had my client, these are the facts of the case, were my client and her daughter attacked outside of a nightclub by two very large, determined, and aggressive men, she wouldn't have thought to herself, okay, I want to act in self-defense. I wonder what's the burden going to be at a later stand your ground immunity hearing 2 years later. What she would have asked to find out if her conduct was lawful or not was what are the actual substantive elements of a claim of self-defense? Did I reasonably fear death or great bodily harm?
So I want to ask you one question before you sit down.
Yes.
I know you all don't want to talk about it, but in my mind, it's an open question for me, and I think it needs to be addressed, at least for me. There are tons of statutes, as I understand it, where the legislature has set out burden shifting and sets out a standard of proof, whether it's beyond a reasonable doubt, clear and convincing, and whatnot. If we are to find those to be procedural, why are not all those suspect for constitutional purposes, given that the test is at least similar, not the same? And it cannot just be that in every case the legislature passed an intertwining law. If I looked, I haven't, but if I looked, I'm sure some of those laws were standalone laws where they just, this is the burden and that's it, without intertwining it with something else when, at the time it was passed. How do those litany of statutes not cause concern for us from the constitutional perspective?
Justice Luck, when we were litigating this question at the circuit court level, I looked and we put together the very large list of burden of proof provisions. From my recollection, nearly all of them, if not all of them, were in fact intertwined with substantive bills that actually conveyed rights to citizens. So I don't think that there would be many outliers, but the doctrine as you've announced it, and I think that then Judge Kennedy's decision for the Second District in Cartwright really lays this out nicely. Under your precedence, if a procedural provision passed by the legislature is intertwined with substantive rights, meaning here is a bill with substantive protections, and here is how the legislature wanted them to be processed in judicial proceedings, then that is perfectly acceptable.
But you would agree that if there is a standalone bill, not, in other words, not like what happened in Smiley or in Cartwright, but
I think if there was a standalone burden of proof provision that would very likely be problematic because, as we've said, that would be procedural.
okay.
So do you agree with the, I mean, the state seems, they say in their brief that basically we have to deem it procedural to address the Article 10, Section 9 and deal and consider it sort of quasi-substantive to avoid, this problem. And even they cite a case where it says that something can be procedural for one
Right.
purpose and not for another.
Right.
But so, I mean, do you agree with them though that we would have to sort of thread that by by saying that it's substantive for one and procedural for the other?
No, Your Honor, and the reason for that is because the tests truly are distinct. When you're talking about legislative intent under retroactivity, it is substance versus procedure, but it's not nearly that simple when you're talking about the separation of powers question. There, it's not enough that a law be procedural to violate the separation of powers. It must also be a standalone procedural right that was conveyed. The formulation that you've used is that the legislature has the authority to adopt procedural provisions if they are intimately related to or intertwined with substantive rights in the bill. And just looking at the face of the statute we're talking about here, 776032, you'll notice that subsection 1 is what Dennis said was the substantive right to immunity, and then subsection 4 is just a part of that, and it's wrapped up with that substantive protection. That doesn't make it substantive itself. It's still clearly procedural when you look at it alone, but it's intertwined with and therefore is within the purview of the legislature.
And if we look at it the way Justice Kennedy is suggesting, which I think is kind of echoing the Scalia concurrence in Landgraf, it basically takes the substance and procedure and even the retroactive label off the table and just says, what is the legislature actually legislating on? Here, they're not talking about the underlying conduct. They're talking about these hearings. The hearing hasn't happened yet, therefore, we just apply it. And we don't need to even get into the whole retroactivity thing because nothing's being applied retroactively if you look at it in terms of what it's actually governing. And so is it true then that the only reason why we need to get into all these labels and distinctions is to deal with the constitutional issues?
The way that
to understand how we should look at it constitutionally?
I think it would be a very fair way to look at it. The reason that we've talked about it that way in the brief is because your cases say that even under the legislative intent question, you do draw the divide. Those are not always helpful labels, but I agree that whenever you're talking about something procedural, and whether you want to call it procedural or not, the judge at that hearing after the effective date is just applying. He's not reaching back and changing conduct. That was
retroactive. It's a misnomer in that sense.
I think that's right. The only reason we use the phrase retroactivity is because it's a useful shorthand, but you're quite right that nothing retroactive here is happening because the legality of my client's conduct is not changing one way or the other. Post-amendment, if she acted in self-defense under the substantive provisions of the law, she also acted in self-defense afterwards and vice versa. If her conduct was originally unlawful and now we have the burden of proof change, it's still unlawful. The question is, how do you prove it within the confines of a judicial hearing, which is classically what you've called procedural.
You're now into your rebuttal time.
Thank you so much.
Good morning, Mr. Chief Justice, and may it please the Court, Solicitor General Amit Agarwal appearing on behalf of the state of Florida. And I'm pleased to be joined at counsel's table by Deputy Solicitor General Christopher Baum. Unless the Court would prefer otherwise, I'd like to start out by addressing Justice Muniz's question to opposing counsel about the relationship between the constitutional inquiry on the one hand and the statutory retroactivity analysis on the other hand. And I think the answer to that question, Your Honor, is that one of the big differences between our position and the position of the petitioner in this case is that, in our view, this Court's decision-making process should not be dictated by conclusory and formalistic labels like substance and procedure that employ vague and malleable terms that can be selectively invoked, sometimes by the same party, in the same case, in inconsistent ways in the same brief, to justify preferred outcomes in different contexts.
Well, if that's so, wouldn't that push us toward what the line of analysis that I started out referring to, in which I did not echo Justice Scalia, but shamelessly parroted him, what he says in his concurrence in Landgraf. So that seems to me, when I listen to what you're saying, I'm saying, you're channeling what Justice Scalia said there, but that doesn't seem entirely consistent with where you end up.
Well, our position is that with respect to both inquiries, the constitutional separation of powers analysis and the statutory retroactivity analysis, what ought to control is not the label, but a close look at what this law does in the real world, what practical impact it has, and under this court's established jurisprudence, even if a law can be deemed procedural in some respects, substantive in another respect, that doesn't dictate the outcome of either the constitutional analysis or the statutory analysis. What you do is you look at, as a practical matter, whether this is the kind of law that implicates the concerns that animate this court's retroactivity jurisprudence, as well as the Supreme Court of the United States' retroactivity jurisprudence. And maybe the best way I can...
But again, when the state comes in and talks about, retroactivity, I'm confused. Because the legislature can impose things on the state. I mean, that the legislature is the state in an important way. So when we look at this statute that talks about the burden of proof in immunity hearings, and it has an effective date, I'm struggling to understand why we would not just take the legislature, what they say at face value, and so that after the effective date of that statute, if an immunity hearing is held that's within the scope of that statute, that the new burden of proof would apply. It just seems like to me, if they wanted it not to apply, to cases that involved conduct that had occurred before the effective date, they could have said that. If they wanted it to apply even in cases where the hearing had already been held but weren't final, as the second district said, they could have said that. But they didn't say that. They said effective, and this is the burden of proof. I don't understand. So I'm just struggling with why that simple way of looking at it is not appropriate in this context.
I think the reason why it's not entirely appropriate, Your Honor, is because the question at the end of the day is not whether the court uses the word retroactivity. Our argument at the end of the day is not that the statute shouldn't be applied retroactively. Our argument is that the statute should not be applied to pre-enact claims of immunity that are predicated on pre-enactment conduct.
But the legislature is not talking about pre-enactment conduct. I mean, it's a different thing, perhaps, if the legislature was talking about the conduct. But why is the relevant inquiry, as Justice Scalia says, not that the relevant activity that the rule announced by the legislature actually regulates?
I think there's a legal doctrinal answer to Your Honor's question, and there's maybe a more policy-based answer to the question. The legal doctrinal answer, as we understand it, is that this court's prior cases have concluded that if a law substantially affects substantive rights and imposes new legal burdens, then you have to proceed on the assumption that the legislature did not intend the law to apply to claims predicated on pre-enactment conduct unless the legislature clearly evinced an intent to the contrary.
Doesn't that whole line of doctrine arise in a context where we're concerned about vested rights of private parties? I'm having a conceptual problem in understanding how we pull that over into this context where we're talking about the state and what the legislature has said, a burden that the state has to meet.
Yeah, I don't think it's just about the vested rights of private parties. In this very case, for example.
But how exactly, I mean, what substantive right really changed here? Because the person who is being criminally prosecuted is a private citizen, not the state, obviously.
That's right.
And the substantive right in Section 1 remains the same, which is that you are the ability to be prosecuted. You're immune from criminal prosecution if you did certain conduct. If you acted in a way where you thought that you were being threatened or you reasonably should have known So there's certain standards that have to be met. So the only thing that changed was Section 4, which was the burden of proof and the quantum of proof. And that all then changed for purposes of the states. But how exactly is that imposing a new legal burden on a private citizen?
So I guess the way I would put it, Your Honor, is that the law changes the who, the what, and the how with respect to establishing a claim of complete immunity from criminal prosecution. And so the substantive right that is affected by this amendment is what this court in Dennis versus State identified as a substantive right to immunity, not from criminal liability, but from criminal prosecution. And if I may, perhaps I could just walk through the who, the what.
Let me ask a question first. I haven't gone back and researched how we got here, but my guess is that it's the sort of unique savings clause that we had until very recently in the Florida Constitution that said that amendment of a criminal statute cannot affect prosecution for crimes that occurred prior to the effective date of the statute or something similar to that. And that would seem to, I mean, the plain language of that, I mean, this certainly would affect your prosecution, changing the burden of proof.
Yes.
And so I'm guessing that that's how we got here, and you, in your brief, are relying on that language. Does it affect the argument at all that that constitutional provision has been changed and no longer applies? I mean, now it's only the repeal of a criminal statute that cannot affect prosecution. So given that change in the constitutional language, which is the only constitutional provision that I think that could affect or directed the underlying law in this area, why is this an issue now?
We think the recent change to Article 10, Section 9 doesn't affect our argument or the court's analysis because we were relying on Article 10, Section 9 for the proposition that it helps to assess what the legislature's intent was at the time that it enacted this amendment. And that was on the basis of the theory of constitutional avoidance.
And you would agree that we should look at what the statute says before we start asking what the legislature intended?
Absolutely.
Okay.
Yeah.
Doesn't and this goes to the answer you had given to Chief Justice Kennedy and also Justice Lawson, aren't we really flipping, it seems like in the briefs at least, we're flipping the analysis. We're asking, is this substantive or procedural, because there are presumptions that go along with that, and only the clear legislative language can seem to overcome some of those presumptions. I think that's directly from your brief. And but in answering Justice Lawson's question, I think I heard you say, and I think that's probably correct, no, we need to look at the language of the statute first before we engage in this constitutional analysis of procedure and substance. Is that right? Do we look at the language first and then decide procedure or substance, or do we decide procedure or substance first and then language, and why?
So we take this court's case law as we find it, and the court's case law is enunciated in cases like Arrow versus Walsh, Smiley versus State, and other cases that have been cited in our brief.
You don't always do that. Frequently you say it's wrong. And we should look at the language of the Constitution
Those are
or the
rare.
statute.
Well, if there were any kind of tension, Your Honor, between a decision and a constitutional requirement, we would bring that to the attention of the court. I don't know that that's the case here. And our argument with respect to statutory retroactivity does not turn on any kind of constitutional analysis at the end of the day.
I agree, but the statute, though, does seem, and this goes also back to something Chief Justice Kennedy asked you, the statute does seem to indicate that, and I'll read it, once a prima facie case of self-defense immunity has been raised, in this case it was raised, at the preliminary, the pretrial immunity hearing, which had not yet taken place yet, then the burden will be on the state by clear and convincing evidence, and that it shall take effect immediately. Why is that not exactly on point to indicate that where a prima facie case has been raised and there has not yet been the pretrial hearing, that it shall take effect for that pretrial hearing?
Mm-hmm. And that's absolutely one way to read the statute.
Is there another reasonable way to read it?
It is, because we, under this court's jurisprudence, case law sets out default rules against which the legislature acts.
My question to you is different than that, and I understand. My question to you is there another reasonable way to read what I just read? Not forget case law, forget presumptions. Reading the language as we do under the rules of construction, is there another way to read it that's reasonable?
You certainly could, but, Your Honor, we think that statutes that have been enacted by the legislature should be interpreted on the assumption that the legislature knew what this court's decisional law was at the time. That provides a clear statement against which the legislature, clear background rule against which the legislature can act. And if I may,
So the
I would like-
legislature, though, would have to, when they wrote that, they would have had to be thinking that this goes into the arrow error box as opposed to the things that have been characterized as procedural. I mean, it does seem like the argument that you guys are making to try to analogize this to the cases where there are new causes of action and people's behavior is either legal or not, you know, depending on what the statute says. I mean, it doesn't seem like those cases really apply to this.
Well, let me put it this way, Your Honor. A lot of those cases talk, as opposing counsel mentioned, about changing the element of a claim. And we think that when you look past the burden of proof label and look at the plain language of Section 776.032, subsection 4, what it's really doing is not just changing the burden of proof. It's changing the elements of a claim for immunity from criminal prosecution in contradistinction to a claim for immunity from criminal liability. Why does it do that? Well, like I was saying before, that's because the amendment changes the who, the what, and the how with respect to this claim for immunity. In terms of the who, under the old version of the statute, the government, the state, didn't have to prove anything. Now, it's the state that has not just a higher quantum of proof or a higher burden of proof. It's the state that has to prove that the defendant was not entitled to immunity. So the who has changed. You have a complete transfer of the burden of persuasion from one party to another. That, in our view, is not just changing the burden of proof, it's changing the legal standard that governs the adjudication of a claim for immunity from prosecution.